MY, children adoption order setting aside.
Yes, it's a good one.
My Lords and my Lady, I appear on behalf of the appellant, AM, leading Mr Day and Miss Smith. My learned friend Mr Norton, King's Counsel, leading Miss Richards and Miss Jane, appear on behalf of BM. My learned friend Mr Bow, King's Counsel, leading Mr Cooper Hall, appears on behalf of Y. My learned friend Miss Markham, King's Counsel, leading Miss Cann on behalf of X. And my learned friend Miss McClin, King's Counsel, leading Mr Wilson on behalf of the Secretary of State for Education. In addition, of course, the court has written submissions on behalf of 3 interveners, Coram Bath, the International Centre for Family Law Policy and Practice, and the Association of Lawyers for Children. The court knows, of course, that the parties have used generic initials in referring to their respective clients in order to achieve anonymity.
Yes, at some point, are you going to address us on?
I was going to invite the court, in fact, we collectively invite the court, my lord, to make a reporting restriction order in standard terms, which I can set out.
And on what basis?
On the basis that the children's...
Well, they're not children.
Well, on the basis that the children's...
They're adults.
The adult parties who were formerly children's interest in anonymity should be preserved as much now as when they were children, because their private life engages the same issues now that they're adults as it did before when they were children.
Yes.
Was an order made in the courts below?
An order was made.
And where did we find that? What's the terms of that?
Well, the terms would have been that no one would publish or reveal the name or addresses of the children or any information which will be likely to lead to their identification or any member of their family.
Do we have a copy of it?
I don't think we have a copy of an order in those terms in the bundle, my lord. That would have been standard procedure in the Court of Appeal.
Well, I think in that case, I don't think there's much point in our going through this at the moment, but we'll need to see the terms of any order that there may be, and we may need to think about this, because speaking for myself, I don't see any need for us to go into the facts of
Indeed.
this case, any personal matters, because it's a pretty technical point of law we're actually having to deal with, I think.
My lord, I agree, and I was certainly going to indicate that I do not intend to take the court at the outset or at all through the statement of facts and reasons which the court will have read. There'll be some reference to the children's or the former children's respective positions arising from the different orders made by the court at different times, but as to particularity, I was certainly not going to go into the background facts.
Fine. Well, we may need to come back to the issue, but I think we can park it for the moment.
My lord, thank you. I've introduced my learned friends in the sequence in which you will hear them, and the court obviously has a talk time schedule as well in terms of the duration of each of our addresses, subject to anything indicated by the court to the contrary. May I say, by way of purely preliminary point, that the appellant's written case was drafted before clarification of her position by X in terms of her stance regarding revocation of the adoption order made in her case. I should make clear that no party suggests that any court at any time should exercise a jurisdiction to revoke X's order against her wishes. And although the language of my written case has been directed at both children prior to the clarification of X's position, in a sense, so far as the jurisdictional arguments have a foundation in the particular facts of this case, they only pertain to Y. May I summarise in opening the arguments that we put and sketch out our case? Adoption orders have been on occasion set aside on appeal where there has been a procedural error or a breach of natural justice at the time the original order was made. From 2013, and I take that date from the decision of Mr. Justice Bodie in Reed W. that year, there have been a number of reported High Court decisions in which judges have recognised that the inherent jurisdiction may be used to revoke a valid adoption order.
Now, what do you mean by the inherent jurisdiction?
By the inherent jurisdiction, I mean the jurisdiction available to the court to meet a child's needs where they are otherwise not met by a particular statute or other form of legislation. There are different expressions in the bundle of the inherent jurisdiction. Most usefully, I would suggest, my Lord, in the case of Re-T before this court in 2021 relating to deprivations of liberty outside of the statutory scheme under Section 25 of the Children Act. If I could take the court to the references within that authority to the inherent jurisdiction at page 2226, 2226 of the bundle, starting with the judgment of Lady Black, under Section D of the reported decision, Section 100 of the Children Act and the inherent jurisdiction. At paragraph 65, one sees a citation from Lord...
Well, this is dealing with a jurisdiction that the court no longer possesses in relation to the appellant.
Does your lordship mean by dint of the children's age?
When you look at paragraph 65, this is talking about the parens patriae jurisdiction of the Court of Chancery, inherited now by the High Court. But that would end when the children become adults.
Well, there is no restriction in the Family Procedure Rules 2010 in relation to the age of an applicant. And we would say...
You're talking about, this is a common law, strictly an equitable jurisdiction that goes back to the Middle Ages. Wardship is the classic example.
Exactly.
Now, that's a jurisdiction vested originally in the monarch to look after people who were incapable of looking after themselves. So it would be children and people who are mentally incapacitated. But as far as these appellants are concerned, that's now water under the bridge.
Well, in the sense that they are no longer children, but we say there is nothing that precludes the use of the inherent jurisdiction to come to their aid.
Well, look at the case. Have you looked at the case of Abbasi?
That isn't in the bundle, my lord.
Well, it's a case on the inherent jurisdiction decided by this court last year, and it goes into it in some detail and explains that it ends when a child becomes an adult, unless the adult, of course, is mentally incapacitated.
Well, our response to that, my lord, is that when an adoption order is made under Section 1 of the 2002 Act, the court has to consider welfare throughout a child's life. And if it becomes the case that, on our position within this appeal, it is no longer in a child's or a person's interests for adoption order to persist throughout their life, we say that the inherent jurisdiction can nonetheless come to their aid despite their achieving their majority. As I say, there's nothing within the rules of court that stipulates an upper age limit.
There's a quite different inherent jurisdiction, which I thought from some of the material in the written cases might be relied on, which is the inherent jurisdiction of a court to regulate its own practice and procedure, which there are references in the written cases to a well-known dictum of Lord Donaldson. Now, that's got nothing to do with the parens patriae jurisdiction. It's a quite separate head of jurisdiction. But I thought possibly you might be relying on that.
Well, we have put our case, my lord, squarely within the parameters of the inherent jurisdiction relating to children. I appreciate that in some of the authorities, in the appellate authorities, there has been reference to adoption orders being revoked on appeal in the exercise of the inherent jurisdiction. We accept for present purposes that the Court of Appeal, in using such an expression in the past, has been referring to its own powers of disposal when an appeal has been successful, rather than a first instance revocation jurisdiction.
Well, if you're relying on the parents patriae jurisdiction, I think you have to face up to the problem that it's expired so far as these children. I mean, if you look at it in paragraph 65, you see a quotation from Lord Denning explaining what it is. It derives from the right and duty of the Crown as parents patriae to take care of those who are not able to. That's the essence of it. Well, clearly a child is not able to take care of himself or herself, but an adult is, unless you say.
My Lord, if there are identity-related welfare reasons that might justify the use of the inherent jurisdiction in respect of a child, those identity issues will not go away simply because the individual has achieved their majority.
It's not very profitable us having this discussion when you haven't read Abassi, which is all about this very issue. That's the whole point of the case. It's a recent decision of this court. I don't quite know how you want to proceed. I mean, either you can turn to another topic, or we can adjourn if you'd have a look at Abassi and then resume when you've had a chance to consider it. It's up to you.
Well, my Lord, I would prefer to continue with the submissions and to deal in due course also with the two cases that the court sent or had sent to the parties yesterday afternoon. I appreciate that those don't engage with the Abassi question, but otherwise may I proceed as intended?
Very well.
My Lord, I was outlining a summary of the case put by the appellant. I was referring to a number of...
The difficulty is that the case you're relying upon is the court has an inherent jurisdiction. And the answer to that is the inherent jurisdiction cuts across the legislation and the purpose of the legislation. The first question, the anterior question is there an inherent jurisdiction? And at the moment, I can't see where you get it from. I really just, so the first question is there an existing inherent jurisdiction in this case in relation to two adults? And what's the answer to that?
Well, my Lord, plainly we need to consider Abassi before responding to that. Otherwise, I will be repeating the response that I gave to my Lord Reed. And in any event, although the particular facts of this case arise in respect of two adults, formerly children subject to orders of the court, the wider jurisdictional issue will obviously fall to be considered in respect of children who remain children. So from 2013, there have been a number of reported High Court decisions in which judges have
Okay. Well, I think we'd better hear you. I mean, even on the basis of even following Abbasi, the argument would be open. It would be academic so far as these appellants are concerned, but the argument would be open that, at any rate, in respect of people who are still under 18, the inherent jurisdiction is available.
Indeed.
So I suggest you carry on, consider, I mean, no doubt those sitting beside you are all busy reading Abbasi at the moment, and you'll have a chance to look at it during the short adjournment.
My Lord, thank you. We contend that the first instance decisions in which revocation under the inherent jurisdiction has been ordered are correct. As I said a moment ago, we do accept that when orders have been set aside by the Court of Appeal, the Court of Appeal was exercising its powers of appeal rather than a first instance revocation jurisdiction. However, we will say, first, that the appellate authorities do not preclude the use of the inherent jurisdiction in very particular circumstances, of which the present case is a single example. And second, that if the reliance placed on the appellate decisions by the High Court was misplaced, then the inherent jurisdiction nonetheless remained open to the High Court to exercise. We recognise that there are very strong public policy considerations in play in relation to the intended permanence of adoption and finality of adoption orders. But our argument is that this appeal engages the question of how to meet a child's welfare needs when permanency has not been achieved. The context here is not merely about placement breakdown. The facts of this case, which we say are an illustration of exceptionality, involve a child arrangements order having been made to the birth parents, parental responsibility having been restored to the birth parents, and critically, an adoptive mother supporting the revocation. In combination, those factors have created the legal fiction to which various parties allude, and which we and others say would be harmful to perpetuate. In these very particular circumstances, the inherent jurisdiction should be invoked to meet a child's welfare needs. We will say that there is nothing within the 2002 Act that prevents the court from so holding, and that the inherent jurisdiction would not cut across the statutory scheme. And we argue that an affirmative ruling on jurisdiction by this court would be consistent with the ECHR obligations under Article 8, Article 2 and Article 3, particularly in the context of identity. And we invite the court to interpret the 2002 Act with those obligations in mind.
The two girls now have their mother's, the birth mother's surname.
One of them does.
Why does? Okay.
I make clear that we are, and I set this out in our written case at paragraph 9, we are not seeking a declaration of incompatibility. My learned friend Miss Markham, King's Counsel on behalf of Ext, raised in her written case an argument in relation to reading down the statutory provisions under Section 3. That is not an argument that we have advanced, and I stand by our position in relation to incompatibility. It wasn't argued...
So just so it's clear, you are not relying on Section 3 within the right?
I am not.
Right.
We're grateful to the court for...
So why did you talk about Article 8 at all?
Because we argue, my Lord, that in interpreting the statute and whether or not it excludes the use of the inherent jurisdiction on its terms, the court should have in mind the Article 2, 3 and 8 obligations, and that will assist in an interpretation that leaves open the availability of the inherent jurisdiction in these circumstances.
Right, but if an interpretation which is urged against you that an adoption order is to be final according to the statute, is compatible with Article 8, I'm understanding you to accept. I can't see that referring to Article 8 helps one way or the other on the application of the ordinary statutory.
Well, my lord, we say that the statute taken as a whole, the statutory scheme, is not incompatible with the convention, but that is because one can interpret the statute explicitly as not excluding the use of the inherent jurisdiction. There's nothing within the language of the statute that excludes the use of the inherent jurisdiction.
Right, but if you lose on that argument, I'm now understanding that you accept that you can't rely on, or you're not seeking to rely on Section 3.
My lord, that is right. If we lose the argument in relation to the interpretation of the statute and whether it excludes the inherent jurisdiction.
So why refer to Article 8 at all?
Well, we say that the interpretation of the statute and whether it excludes the inherent jurisdiction has to take into account the children's Article 2, 3 and 8 rights. Right.
But the predicate for my question is, suppose you lose the argument that there is finality. I understand your position to be, well, we don't seek to rely on Section 3 in those terms.
That's correct.
So isn't it inherent in that answer that you accept that interpretation of the statute as producing finality is compatible with Article 8? Because if it wasn't, one would usually expect you to be arguing, well, if I don't win on ordinary canons of statutory interpretation according to domestic law, I can win because Article 8 rights are engaged here and they require that the inherent jurisdiction be continued, and therefore Section 3 of the Human Rights Act leads to that conclusion.
Well, my lord, we do not go that far.
No, so why talk about Article 8 at all then on your case?
Because we say the children's Article 8 rights are fully engaged in terms of identity.
But I don't understand this. Either a conventional interpretation of the statute is compatible with Article 8, right, or it's not. If it is, Article 8 adds nothing. If it's not, you have to rely on Section 3.
Well, my lord, I don't intend to make submissions that shut out the relevance of the Article 8 rights in this case.
How is it relevant? How is it relevant? I mean, are you saying that the statute, without regard to Article 8, is compatible with the Convention or incompatible with the Convention?
We are saying that it is compatible with the Convention.
It's compatible. Well, in that case, Article 8 adds nothing.
Anyway, that's your position. So, I mean, I'm not sure why on your case we get into Article 8. It may be that on other people's cases we do, but I'm struggling to see why on the case that you're presenting, Article 8 is relevant at all.
Well, I understand your lordship's point. If we have miscalibrated the Article 8 argument in our written case, then I will have to address that in due course. But we certainly make submissions that Article 8 considerations are relevant to the children's position because of their identity issues.
All right. But well, just so you know, if you are going to rely on Article 8 in that positive way, I don't understand why you forswear reliance on Section 3 of the Human Rights Act.
I understand your lordship's point.
Okay, well, eventually we'll need to know what your settled, considered position is in relation to that.
My lord, yes.
And what do you mean by identity?
I mean a child's legal status vis-à-vis other important people in the child's life. I mean a child's sense of self, and I rely on the way that the International Centre for Family Law Policy and Practice have articulated their written case in relation to identity. I refer to their paragraph 12 at 183, our identity and selfhood, which are initially attributed to us by others at birth, are then built, shaped and developed by each of us throughout our lives. Identity is a critically important personal hallmark. It tells us and others who we are and provides our horizon.
I'm so sorry, I missed the reference.
The reference, my Lord, is paragraph 12 at 183 of the written case advanced by the International Centre for Family Law Policy and Practice.
Right.
My Lord, I was going to set out the basic structure of the statutory scheme that leads to an adoption order. I won't do that if it's not of assistance to the court. The court will have read something about that, certainly, in the parties' respective written cases. The pathway that most children take to adoption is through the making of a care order under Section 31 of the Children Act, and then a placement order under Section 21 of the 2002 Act, which authorises a local authority to place a child for adoption with any prospective adopter whom it may choose.
In this case, the adoption order was made by a county court judge, and it was before the family court was set up, as I understand it. What's the present position in relation to which tier of the judiciary makes an adoption order now?
An adoption order can be made by, well, typically it's made by a circuit judge in the family court. Rarely would a domestic adoption case be before a high court judge.
So it's either a circuit judge, it's assigned to a circuit judge or a high court judge, is that right?
Yes, I mean, usually a circuit judge.
And then if the adoption order is being appealed, is it being appealed to, within the family court, to a high court judge?
The adoption order would be appealed to the Court of Appeal.
From the circuit judge?
From the circuit judge?
Indeed.
Right. And is that different from other orders made by a circuit judge?
Private law orders made by a circuit judge are now appealed to the High Court, but public law orders not.
To a High Court judge sitting in the family court or to the High Court?
To a High Court judge sitting in the High Court.
Right. Thank you. At some stage, if you could, and it's not relevant now, and it's not the major, it's just a procedural issue. You couldn't just set out in a written note what the appeal provisions in relation to an appeal from a circuit judge to the Court of Appeal in relation to an adoption order, and the power of the Court of Appeal to extend time.
My Lord, yes.
Thank you.
And if I could say, it would probably assist us to know the position as at the time when the adoption orders were made in this case, which I think was back in 2012 or thereabouts, and what the position is now, because we might have to cover both.
My Lord, yes.
And it raises another question, and that is, if the appeal is from a circuit judge to a High Court judge sitting in the family court, which I understand you say it's not, does a High Court judge sitting in the family court, which is a creature of statute, have any inherent jurisdiction?
We would say that a High Court judge...
Well, it might like to reflect on that.
My Lord, yes. So I was outlining the position in relation to a child's passage into an adoptive placement through a care order and a placement order. A placement order requires a parent's consent to be dispensed with under Section 52 of the Act, but only if the child's welfare requires it. And importantly, under Section 52(6), a parent is defined as being a parent having parental responsibility.
And could you just assist me, the page number for that in our bundle?
Is 2493, my Lord.
Thank you very much.
An adoption order is then made at some point after the child is placed, and an adoption order also requires the parent's consent to be dispensed with under Section 47, and the Act provides then that a parent may not oppose the making of an adoption order without the leave of the court. In turn, leave to oppose an adoption order cannot be given unless there's been a change of circumstances since the placement order was made. See section 47, subsection 7. When any court is coming to a decision about the welfare of a child in an adoptive context, under the statute, it will be applying the welfare paramountcy principle in section 1 of the Act, which requires welfare throughout the child's life to be analysed. And that is...
I'm so sorry to keep asking for the references, but it would assist me at any rate.
I will give them.
Section 1?
Section 1, subsection 4, reference 2268.
Thank you.
And the welfare checklist under the 2002 Act is different to that under the Children Act, my Lord, because it includes the words throughout his life. So the court is engaged in evaluation of welfare at the point of making an adoption order that looks prospectively at the impact that an order will have on the child throughout his life. And we entirely accept that the purpose and intention of the Act is to create a permanent adoptive status for a child. But the question facing this court, we say, is how to approach a child's welfare when her adoptive identity has been completely eroded, and the court's original conclusion that an adoption order will meet her welfare needs throughout her life has proved in time to be completely wrong.
I'm so sorry, I'm reading too slowly on 2268 to 9. Where do we get throughout?
1 subsection 2.
Oh, gotcha. Yeah, thank you. Yeah, thank you.
The Act, as the court will have read, sets out the effect of adoption and the change of status that arises, and these are important provisions. First of all...
Sorry, just on that, I mean, this is section 1, subsection 2, states the paramount consideration in relation to a decision relating to the adoption of a child. Now, that's a decision that's taken at one specific point in time, and it's perfectly possible at that particular point in time for the court to do the best it can looking forward throughout the child's life, decide, having regard to the criteria in section 1, subsection 2, yes, it is in the child's interest having regard to its welfare throughout their life, or it isn't. So I'm not sure how or whether section 1, subsection 2 helps very much on the particular argument that we're addressing as to whether an adoption order is final or not.
Well, the relevance of it is that in the exceptional circumstances of a case such as this, we say it has become very clear that the child's welfare throughout her life will not be met by adoption because the child entirely rejects her adoptive status, is no longer living with an adoptive parent, and the court's prospective evaluation of how welfare will how her welfare will be and how an order will serve her welfare interests throughout her life has proven to be completely unfounded. So we say there is some significance in terms of the revocation argument of that phraseology in section 1, subsection 2, because the core purpose of the adoption order, which is to meet a welfare need on that basis, has been thwarted. And if that is the case, we say that there needs to be a jurisdictional platform to enable a court to look again as to whether an adoption order continues to meet the child's needs.
Yes, thank you.
Looking at page 2271, a few pages on of the bundle, one sees the first of two important statutory provisions that relate to the impact of an adoption order. So first of all, section 46, subsection 2, the making of an order operates to extinguish the parental responsibility which any person other than the adopters or adopter has for the adopted child immediately before the making of the order. And the second important provision at page 2278 is section 67, the status conferred by the adoption.
Well, sorry, just on section 46.2, I mean, that says the making of an adoption order operates to extinguish the parental responsibility. I mean, just as a matter of ordinary language, that looks like a one-off event, and you've already agreed that there's no difficulty about applying section 1, subsection 2 at the time when the court is deciding whether to bring about that one-off event. So, I mean, isn't section 46.2 difficult for your case?
Well, section 46.2, read in conjunction with section 67, which is the change of status I'll just come on to in a moment,
Right.
are important points relied upon by the Secretary of State in opposition to the revocation argument. That the language of the statute says nothing about the permanency of the extinction of parental responsibility under section 46.2, and for reasons that will come on.
Well, isn't the concept of extinguishing the parental responsibility something that suggests finality, that extinguishment means extinguishment? There doesn't seem to be a suggestion it can be revived.
Well, on the face of it, it might be taken to suggest finality, but we say, reading the statute as a whole, and thinking in particular about the language used under section 55, which is the revocation under legitimation provision, we say that the statute does not say that the extinction of parental responsibility must be for all time. The statute could explicitly have added that provision, but it does not.
Yes, I see. Sorry, I interrupted you. You wanted to take us to section 67.
So section 67, which is at 2278, in subsection 1, an adopted person is to be treated in law as if born as the child of the adopters or adopter. And that supplements the previous provision in relation to the loss of parental responsibility and makes clear that the adopted person's status going forward derives entirely from their relationship with their adoptive parent. And the same observations about the lack of additional language within that provision, about which I addressed the court on section 46, we would say applies to section 67. So, my Lord, we then turn to section 55, which is the previous page 2277. This is the sole part of the statute that deals with revocation on legitimation, where any child adopted by one natural parent as sole adoptive parent subsequently becomes a legitimated person on the marriage of or formation of a civil partnership by the natural parents. The court by which the adoption order was made may, on the application of any of the parties concerned, revoke the order. In terms of the interpretation of that provision, we make two essential points, which is that the statute could very easily have said at section 55 that the only means of revocation is in circumstances where revocation is needed to address the position of a legitimated person.
But isn't that what it does say? It didn't need to use the word only. That is the only situation.
Well, it's the only situation that the statute sets out, but the statute doesn't extend its reach to preclude the use of the inherent jurisdiction, as, for example, does the Children Act. So our second core submission in relation to the interpretation of the 2002 Act, aside from the omission of the word only within section 55, is that there is no parallel provision to section 100 of the Children Act, which the court can find at 2421 of the bundle.
That the provision that excludes the inherent jurisdiction.
It limits the
Or limits
use
it.
of the inherent jurisdiction. It's entitled restrictions on the use of wardship jurisdiction and makes clear, first of all, that subsection 2, that no court should exercise the High Court's inherent jurisdiction with respect to children so as to require a child to be placed in the care or put under the supervision or accommodated by a local authority, or to make a child who is a subject of a care order a ward of court, or for conferring on any local authority power to determine any question which has arisen in connection with any aspect of parental responsibility for a child. So a local authority cannot ask a court to do any of those things in circumstances where the Children Act sets up a statutory scheme for taking children into care or being placed under the supervision of a local authority.
Sorry, can I just check this? Was it ever part of the inherent jurisdiction to bring about adoption? I thought adoption is a concept which is a creature of statute from, I think, 1926.
That's correct.
So you in order for transfers of parenthood to be brought about, you need to be within the statutory scheme, don't you?
That's correct.
The inherent jurisdiction doesn't clothe the court with power to do that.
It's never been part of our case or anyone's case that the inherent jurisdiction could be used to create an adoption. This is about whether...
Not create an adoption, create an assignment of parental responsibility, which may amount to something similar, but it's slightly different because you're wanting the BMs to have assigned back to her the parental responsibility in relation to the children.
Well, she was given parental responsibility in respect to the children by reason of the child arrangements order and parental responsibility grant made by Judge Plunkett in May of 23.
Right.
That's not the issue. The issue is the status of parenthood,
Okay.
which fell away as a result of Section 67 of the Act. So parental responsibility has been stored, but her essential recognition as a parent of the children has not been done.
All right. Well, redo my question in terms of parenthood rather than parental responsibility. On my understanding, the inherent jurisdiction of the court never extended to assigning parenthood.
That's correct, my lord.
Differently. So changes in parenthood, which run with adoption, has to be a product of the statutory regime. Is that not right?
The creation of parenthood has to be the product of the statutory regime, but in circumstances where the statutory regime doesn't address the needs of a child for whom that parenthood has become a potentially harmful issue, the inherent jurisdiction can step in.
Well, that's what I'm struggling to understand. How can it step in? Because the inherent jurisdiction never extended to assignment of parenthood, whereas what you're seeking to achieve is an assignment of parenthood.
Well, we're not seeking a creation of parenthood. We're seeking a restoration of parenthood, from the birth parent's original status. I appreciate that that was extinguished upon the making of the adoption order, but it's a different thing to parenthood being created by the statute, to reverse it under the inherent jurisdiction where it's necessary.
That's what I'm pressing you on. Why is it a different thing? I mean, the statute has brought about the transfer of parenthood to AM. So the law has provided that AM has parenthood. You need something to transfer that parenthood back to BM.
And not only transferred it, but extinguished BM's parenthood.
Yes, because I think everyone's agreeing. There's just one sort of element to parenthood that is passing between different natural persons. So why isn't the essence of your case that somehow the courts do have to procure a transfer of parenthood back from AM to BM, the law having provided that AM is now the person with parenthood?
If an adoption order is revoked, then the legal position prior to it being made would subsist, and the parental responsibility for the child would then be held by the local authority.
I mean, that I understand, but that's to say that's the consequence of the argument you want to present. But
Yes.
isn't it inherent in your argument that you're saying that the court now has power through some exercise of its jurisdiction? You say it's just revoking the previous adoption order to bring about a transfer of parenthood from AM to BM. It seems to me that has to be your case, doesn't it?
I don't know whether I associate myself with the word transfer, my lord. I would say that BM's status as parenthood would be revived because it would be as it was before the adoption order was made, and the adoptive parent's parenthood under Section 67 would be reversed by the revocation.
All right, thank you.
So, under Section 100 of the Children Act, one can see under subsection 3 that no application for any exercise of the court's inherent jurisdiction with respect to children may be made by a local authority unless the authority have obtained the leave of the court. So our point in relation to this is that one statute explicitly precludes or limits the use of the inherent jurisdiction, but the Adoption and Children Act doesn't. And in those circumstances, the court should not hold that it excludes the use of the inherent jurisdiction. I want to move on to address the court in relation to broad welfare principles, which we say apply in this case. Obviously, the court already has Section 1 of the Adoption Act. We have been through that, and we've been through the prospective exercise in relation to welfare evaluation that the court must undertake at the time of making an adoption order. There are aspects of the Section 1 welfare checklist at 2268.
So what page number again, sorry?
At 2268.
Thank you very much.
That clearly relate to identity, most particularly subsection 4C. The court or adoption agency must have regard to the following matters in the checklist, but 4C is the likely effect on the child throughout his life of having ceased to be a member of the original family and become an adopted person. So the Act requires the court to evaluate the impact on the child of the loss of the birth family and of the acquisition of a new adoptive family. Those considerations relate squarely to identity and status. We have also outlined in our written case the international instruments that are relevant to the question of welfare and identity. The United Nations Convention on the Rights of the Child, at Article 3, which the court has at 2265, makes clear that the best interests of the child shall be a primary consideration in all actions concerning children. And Article 21, which I fear is not in the bundle, indicates that the best interests of the child shall be the paramount consideration in the context of adoption. It is uncontroversial that a court, when construing and applying the 2002 Act, must bear in mind the provisions of the UNCRC, and we rely on Lord Neuberger's observations in Re B at page 1974 in that respect. Article 8 of the Convention at 2266.
But sorry, just on the UNCRC.
Yes.
That doesn't provide that an adoption order has to be revocable, does it?
It doesn't.
So perfectly compatible with that convention that one has finality attaching to an adoption order.
Well, there's nothing, I have to acknowledge there's nothing explicit within that convention that says that powers of revocation must be available. But my point is a broader one, which is about the emphasis it places on welfare and identity needs when considering any issue relating to a child.
But that's covered by Section 1, subsection 4.
In the context of making an adoption
Yes.
order, my lady, it is.
It is.
But we
I don't see how the convention therefore helps.
Well, we rely on it for emphasis when considering revocation outside of the terms of the statute.
But it doesn't say anything about revocation.
But it says something about identity. If we look at Article 8 of the UNCRC, which is at 2266, subsection 1 is that states parties undertake to respect the right of the child to preserve his or her identity, including nationality, name and family relations as recognised by law without unlawful interference. As far as Article 8 of the European Convention is concerned...
I'm so sorry. I can't see how Article 8 exists, because that's respect the right of the child to preserve his or her identity, including nationality, name and family relations, as recognised by law without unlawful interference. Well, here it's the adopted identity which is recognised by law.
Subject to the availability of the inherent jurisdiction, we would say.
Right, but Article 8 doesn't assist us to know whether there has to be an inherent jurisdiction as a matter of international law, which could feed through into the interpretation of the statute. And indeed, I think in answer to my previous question, you accept the UNCRC does not require that an adoption order has to be revocable. So I just don't see how it helps us in determining the issue that we have to determine, whether as a matter of interpretation of our statute, an adoption order is revocable or not. Because either of those positions would be perfectly compatible with the UNCRC.
If a child's identity needs are such that an adoption order is no longer in their welfare interests, we argue that the UNCRC comes to the aid of the child, not in indicating that revocation must be part of legislation, but that if there is a means by which a child's identity needs can be recognised, here through the use of the inherent jurisdiction, then that means should be adopted and that path taken.
And that sounds like you do wish to make some submission that the UNCRC does require that an adoption order be revocable in some circumstances, but I had understood you to accept that it doesn't require that.
Well, I'm not saying that UNCRC places an obligation on a state to legislate for adoption revocation, but where a means is already available under the inherent jurisdiction, we say that that is consistent.
But that's the very point that's an issue. Is a means available? We've got legislation, it has to be construed, it's being said against you. If you construe it, if there is an inherent jurisdiction, and we've raised various issues about that, but even if there were an inherent jurisdiction, it's being said against you. On ordinary principles of interpretation, the legislation excludes that. Now, as I've understood your answer so far, you do not, against that argument, intend that, well, you can't construe our legislation in that way because there's some obligation in public international law deriving from the UNCRC that says, actually, a state does have to ensure that any adoption order is revocable in some situations. I don't understand you to have made that submission so far, but we do need to understand if you are making that submission, and if so, how you support it.
Our submission is that the UNCRC adds weight to the argument that the inherent jurisdiction is a route by which child's welfare needs should be met.
All right. Last question from me. How can it add weight if it doesn't create an obligation on the state to ensure that any adoption order made in the jurisdiction of that state is revocable in some circumstances? How can it add weight?
Well, There may not be an obligation on the state to legislate specifically for revocation. I must accept that on the basis of the interpretation of these conventions. Right. Where there is a route that is available, then that route should be taken.
Thank you.
As far as the European Convention...
If there is a route available, you're home and dry.
Yes, we need it.
That's the whole issue. Is there a route available? And the convention, I mean, on your own argument, the convention doesn't give us any assistance in deciding whether or not there is a route. Well, we're an hour into the argument, and I don't think we've made any progress so far.
My Lord, the provisions in relation to the UNCRC are, we say, complemented by the European Convention under Article 8, the right to respect for private and family life, which embraces questions of identity. I hope that submission is uncontroversial, but we can see from the case provided last night, Evans and UK, at paragraph 77, for example, it is said, a number of factors must be taken into account when determining the breadth of the margin of appreciation to be enjoyed by the state in any case under Article 8. Where a particularly important facet of an individual's existence or identity is at stake, the margin allowed to the state will be restricted. So, plainly, Article 8 incorporates identity rights. I referred earlier on to the International Centre's written case in relation to the importance of identity. Within its written case, I cited paragraph 12 before, but I go to paragraph 14 at page 184. In which the International Centre alludes to the opinion of a psychologist who has noted the potential for disruption in identity formation when aspects of identity are suppressed, ignored, or denied. And
So the paragraph number on page 184, sorry?
14, my Lord.
Thank you very much indeed.
And she highlights the dangers for adopted children who may face specific challenges, including attachment difficulties and identity formation, and that potentially devastating events such as attachment disorders are likely to interrupt or cause maladjustment in identity development. Those observations about the potential for a child to experience harm as a result of their identity issues, and the language used there of difficulties that might flow when aspects of identity are suppressed, ignored, or denied, are exactly the kind of issues that face Y in this case. We say it's exactly the suppression or denial in law of her birth identity that is harmful to her.
I rather read that paragraph in the context of the case put in by this body, which seeks, looking at paragraph 51 on page 198, to support the view of the Court of Appeal, as making the point, actually, finality is important, because otherwise the child's identity formation is going to be disrupted because of the uncertainty that might exist if there were any possibility at all.
I certainly accept it was put in for that reason, but it cuts both ways, because if identity issues have arisen as a result of an adoptive placement breakdown, they may be as acute for the subject child as they were at the time of the formation of the adoptive relationship.
Right, but, well, isn't the thrust of the point being made here and in the case generally that once the decision is made that an adoption order should be made, then everything's got to be done to try to make that part of the child's identity, and in a way that isn't disrupted or undermined by the possibility of reversal, which might cause the child not to invest itself in that aspect of their identity formation, might cause the adoptive parents not to invest fully in that aspect of the child's identity formation.
I accept, my Lord, that that is a powerful argument that is put by the Secretary of State in opposition to the appeal. However,
my question was about the International Centre. I appreciate that it's put by the Secretary of State as well, but isn't that the argument being presented in this passage that you've taken us to as part of the case being presented by the International Centre? Quite forget about the Secretary of State.
I agree that that is the context in which they make those observations about identity. I'm simply saying that the suppression of identity may be as important at the time of a breakdown of an adoptive placement, in the circumstances, for example, of this case, as it might be when everybody is trying to shore up the stability of an adoptive placement at its inception. Identity issues can't be compartmentalised purely into circumstances where an adoptive placement is subsisting, because they arise equally at the time of an adoptive breakdown. If a child, we know from the facts of this case that Y no longer identifies at all with the appellant as an adoptive parent, yet cannot be treated in law as the daughter of BM. So her identity needs are being suppressed post-placement breakdown. Our argument is that those identity needs can be expressed through Article 8 at this stage, as much as identity needs under Article 8 were important at the time the adoptive placement was in its infancy, and at the time the adoption order was made, when all parties' intentions entirely appropriately were that the placement would subsist and be permanent.
Just on this point about her identity needs being suppressed, now, I appreciate we're now dealing with persons who are now adults, as Lord Reid has pointed out, and you have to consider what position you're going to adopt in relation to that. But the point's been made that the issue of principle could arise in relation to children who are much younger, who are still children. My understanding is that if someone's still a child, a new adoption order could be made in relation to them.
Under Section 46(5), yes.
Which could reassign parenthood back to the birth mother.
That's correct.
So insofar as one's dealing with children, let's say small children, there is a mechanism that exists to meet those identity needs if they manifest themselves in that particular way. Is that right?
That is absolutely right, but that is likely to apply to smaller children who are, if I can put it this way, readoptable, but much less likely to apply to teenagers who might certainly have an opinion about it and might not want to be readopted. It was Y's position below that she would entirely reject the suggestion of readoption because it would create a further artifice in terms of her relationship with BM. She did not want to be adopted by her birth mother. As it happens, she's now outside the terms of the statute because one can't apply to adopt unless the child is under the age of 18. So that is no longer a mechanism available in this case.
Right.
But you have to have some parent. That's a status that every individual has. You can't say, well, my identity is that I don't want to have any parents.
You certainly can't. And that's not what Y wants in this case. And that is not what we are suggesting could possibly be done.
So the other thing I just wanted to raise with you, once one's dealing with children who have become adults, I mean, one would think that the major part of their identity formation has actually occurred by that point in time. I fully accept that they still have identity concerns and needs, but they're not going to be as pressing as they might be for a small child that is growing up in a family and forming their identity, as a human person coming to maturity. And would you agree with that?
In my submission, it's more nuanced than that, in the sense that that depends on the nature and quality of their relationship with the adoptive parent as they grow up. During the period of their minority in which they are adopted, different children will have different experiences and different relationships of different strengths with the adoptive parents. Now, in this particular case, the appellant was very open-minded and encouraging of the children maintaining contact with the birth mother from an early stage. And it progressed from indirect letters to face-to-face contact relatively quickly. There will be other cases where no such contact takes place at all. So the circumstances on the ground will inform the intensity and quality of the relationship between the child and the adoptive parent, and in turn that will inform the question of whether their identity is complete, one way or the other, by the end of their minority. There will be some children, and Y is a case in point, in which there are no vestiges of an adoptive identity left at the point she reaches her majority.
Right. The reason I raised it in that way was, I mean, you'd referred us to paragraph 77 in the Evans case, which refers to where a particularly important facet of an individual's existence or identity is at stake, the margin allowed to the state will be restricted. And what I wanted to suggest to you is the important facets of an individual's existence or identity in terms of identity formation may be much stronger in relation to a small child than it is in relation to an adult.
My lord, that may be the case, but unless there is a means by which its strength can be evaluated, then the child's Article 8 rights have no means by which they can be given expression.
Right, I see. Thank you.
I could just understand the objection to readoption. If an order is made under which the birth mother adopts the child, then legally the birth mother has always been the birth mother of that child. And just if you could slightly unpack what the objection is to that mechanism and how it is unacceptable.
Well, it involves a relationship between the child and the birth mother, which comes about purely by way of adoption. It is not a restoration of the birth parent's relationship with the child from birth. It is the creation of a new adoptive relationship, and it's against that artifice that Y indicated below she pushed back. It's very clear from the authorities, I'm thinking of Said and Oldham NBC, the decision of Justice Peter Jackson, as he then was, that Article 8 rights are entirely extinguished at the point of adoption, just as the statute provides for the extinction of parental responsibility and parentage. So there isn't a revival.
Section 67(1) provides that an adopted person is treated as if born as the child.
But as an adoptive parent, my lord, that is not a restoration of the birth parent's former relationship with the child. It is the creation of a new adoptive relationship as between child and adoptive parent, albeit that what your lordship has highlighted is the effect in law. As I understand it, Y rejected the idea of her relationship with her birth mother being restored on legal grounds, artificial grounds such as that, whereas the revocation of an adoption order would place her back in the position that she had been in when there was a placement order only in force, where parental responsibility was held by the local authority and the birth parent, as well as the prospective adopter at the time of placement. And it would be the expectation in a case such as this that the local authority would then apply to revoke a placement order, leaving, and the care order that underlined it, leaving parental responsibility purely in the hands of the birth parent. Thus far, I have dealt with Article 8 of the European Convention.
Just before we leave that, can I just raise this point with you? You said, I think, that Article 8 requires or maybe indicates that there should be scope for addressing someone's identity needs if they say that that requires revocation of the adoption order. And I still register my concern that I don't fully understand your case in relation to Article 8 in Section 3, but let's put that to one side. If we are in Article 8 territory, and one reason that we drew to everyone's attention the Evans case and the JR123 case was precisely because those were cases where, in relation to persons' interests under Article 8, the state had introduced what one can call bright line rules, which actually prevented a case-by-case examination of individual circumstances beyond a certain point in time. That was true both in Evans, which related to a very profound interest of the prospective mother in that case, who, because of the bright line rule, was not able to have access to the fertilised eggs that she wanted and needed to have access to in order to have a child. And in JR123, an important interest of a prisoner to be rehabilitated, where they were saying, well, we need to have a system of individualised assessment as time goes by in order to see if a rehabilitation order can be made in the individual circumstance. And in both those cases, the outcome was bright line rule was upheld by an analysis under Article 8. So just before you leave Article 8, I just wanted to see what you had to say about an argument here that by similar reasoning, it's acceptable for the state to have in place a bright line rule that once an adoption order is made, it can't be revoked.
Yes, my lord, we don't accept there is a bright line rule contained within the 2002 Act for the reasons that I've already given in relation to the interpretation.
Right, but if I may say so again, that seems circular. I mean, I appreciate you want to say that, but I thought the point of you going to Article 8 was to present argument to us that ought to lead us to the conclusion that the 2002 Act does not produce finality. I mean, that's the very point of contention.
Yes.
But if Article 8 is compatible, equally compatible, either with finality or not finality, I'm struggling to see how reference to Article 8 assists us in the process of statutory interpretation that we have to engage in.
Article 8 is not consistent with finality, or to put it the other way, finality is not consistent with Article 8, because it doesn't allow the court to examine the child's circumstances when it's all fallen apart.
Right, but then that brings me back precisely to the point I was putting to you about Evans and JR123. Those were both cases of what I call bright line rules, which precisely had the effect that you couldn't have case-by-case examination of the individual circumstances of the two claimants in those two cases beyond a certain point in time. Now, if that was acceptable in those two cases in an Article 8 context, why would it not be acceptable in an Article 8 context here?
Well, Order 8 of the Rehabilitation of Offenders provisions in the JR123 case made explicitly clear what rehabilitation structures would be in place for the claimant in that case. And on any reading of that order, the treatment of his rehabilitation was explicitly prescribed.
But it was that bright line rule that was being challenged.
Indeed.
And the question that you're being asked is, why does Article 8 require an individualised assessment in this case, if it wasn't required in JR123 or indeed in Evans, which is an even more profound interference, if you like?
Because, my lady, the position of a child is an entirely different concept, and there is appropriately a need for flexibility, greater flexibility, as a child's needs change through their minority, and we would say beyond. And it is not appropriate to adopt a bright line rule in circumstances such as that, when to do so would conflict with an individual child's welfare. I can see from the two authorities that there's certainly an emphasis on desirable simplicity in having a bright line rule applied.
Well, it wouldn't be simplicity in this case. It would be the permanence and finality that adoption is intended to achieve.
I mean,
that would be.
Yes. I mean simplicity in the sense that if the appeal fails, every child will have their adoptive identity throughout their lives, irrespective of whether that meets their needs throughout their lives.
But that's not to do with simplicity. That's to do with the importance that's been attached to finality and permanence of an adoption, that it extinguishes the birth parental
yes.
rights.
Milady, I only mean simplicity in terms of simplicity of expectation as to outcome.
Ah, okay.
You really mean certainty rather
I do mean certainty.
But I mean, sorry to press you on that. It's not even true that the child necessarily retains that adoptive identity throughout their lives. I mean, as we discussed before, if you've got a child who is still a minor, there can be scope for a new adoption order to be made, if necessary, to assign parenthood back to the birth mother. I appreciate that in this case, Y didn't want that to happen, but in fact it was available, and even if it was the second best way of achieving that, that is a mechanism that would enable some satisfaction to be given to what you said, the identity interest that she had, isn't it?
I agree, it is a route that could be taken to achieve some satisfaction, although it would require a positive report from an assessing local authority at the time. That's not necessarily a given. There might be procedural or analytical barriers between the child and using section 46(5) for those purposes.
But if in Article 8 terms, you've got to strike a balance between, let's say, the majority of cases where actually finality, for all the reasons identified by the psychologist at paragraph 14 in the International Centre's case, is important actually in the interests of most children, the fact that you've got a safety valve that would allow for departure from that and a reallocation of parenthood in some cases would feed into whether a fair balance has been achieved by the regime overall, wouldn't it?
Well, it certainly feeds into that argument. I have to accept that, my lord, but there will be circumstances in which a birth parent is unable to readopt, either because there's not a positive report or because the child rejects that construct, as was the case here, on the basis of artifice. But of course I accept that section 46(5) does provide, through readoption, a route to restoration of the birth parent's relationship.
Yes.
And status.
Thank you very much.
Could I just bring you back? You were asked by my Lord Sales a question about whether Article 8 is compatible with finality, and you said that it wasn't compatible with finality.
What I intended was to say that insofar as the act is taken to create adoption orders which are final and irrevocable, that is not consistent with Article 8 because a child's circumstances may change.
Well, doesn't that inevitably mean that you're challenging the compatibility of the legislation and relying upon Section 3 of the Human Rights Act? If you say it's not compatible, that the legislation, if it's final, isn't compatible with Article 8, then aren't you then bringing a case that seeking a declaration of incompatibility?
Well, as I said before, my Lord, to my Lord Sales, we are not seeking a declaration of incompatibility.
But are you relying on Section 3 to read the Act down?
We are not, my lady.
But So if it's incompatible, you accept it's incompatible. You're not trying to make an argument.
If the court, if this court decides that the 2002 Act excludes the possibility of revocation outside the terms of the Act,
You'll live with that.
we accept that that disposes of the appeal.
Okay.
Before we leave Evans and the UK and JR 123, both of those authorities also refer to the margin of appreciation. And I appreciate certainly that in terms of social policy, the margin is likely to be wide. I appreciate that where there are different approaches taken by different states, there is a greater call for a wider margin of appreciation. But also, the two authorities indicate that the margin of appreciation will tend to be narrowed where a particularly important facet of an individual's existence or identity is at stake. That's both at paragraph 60 of JR 123 and paragraph 77 of Evans and UK. And plainly, in present circumstances, issues in relation to Y's existence or identity are at stake.
I mean, the margin is also widened where the legislature has looked at the very issue and come to a considered view, which it might be said has happened on multiple occasions in this jurisdiction.
Well, we say
the engagement of Parliament. And what do you say about that?
We say that the legislature has plainly created an act that is intended on its face to provide for permanency, but the Act does not address, my Lord, what one should do when permanency has not been achieved and when there is an adoption breakdown. The Act does not seek to provide solutions in those circumstances. Section 55, the legitimation revocation provision, certainly does not purport to deal with adoption breakdown. And whilst recognising that the contrary argument is that the Act deliberately doesn't provide for adoption breakdown because it doesn't intend any legal consequences to follow or even to be justiciable if there's adoption breakdown, we would say that those are precisely the circumstances when the inherent jurisdiction should be brought in to make sure that a child's needs are met.
Yes, thank you.
And on the two authorities, the ultimate question is striking a fair balance between the rights of individuals and the rights of others and interests of the general community. We do accept it's in the interests of society for children to be placed for adoption with the intention of a stable and permanent placement. But we don't accept that it is in society's interest to maintain the kind of legal fiction that pertains in this case. So there's a social policy about the permanence and stability of adoption, but there's an ancillary, wider social policy by which children's welfare needs are more generally to be met.
Yes, I mean, to go back to the point, I think the point being made in the International Centres case, and I think in the Secretary of State's case, is that if there is scope for debate to continue after an adoption order has been made as to whether it should be continued, that in itself will undermine the identity formation of children who have been placed in adoption and their ability to satisfactorily develop their identity in that family. So one does have a social need to exclude completely the scope for argument, because that would undermine the interests of all those children, as against the interests of some children who later on say, well, this hasn't worked for me and I want it changed. So I'm not quite sure why you say that there isn't a social interest in having a bright line rule in the first place.
It depends on whether or not allowing for the interests of a very, very small minority of children can be taken to undermine the broader social policy of shoring up stability and permanence of adoption. And there has been no evidence adduced in this case that adoption as a social construct has been undermined by the availability, at least since 2013, of an inherent jurisdiction, or a perception of availability of the inherent jurisdiction by High Court judges. No one has suggested that has actually resulted in placements breaking down or there being fewer adoptive parents available. And we would say, in response to the argument that a revocation jurisdiction would open the floodgates.
I'm so sorry. I'm not sure how there could have been evidence about that, because from my understanding, it's essentially been assumed until we had the first instance decisions a relatively short while ago that adoption was irrevocable. So in other words, insofar as there was a social interest in ensuring that it was irrevocable, well, that's been satisfied up till the doubt introduced by those first instance decisions. Isn't that right?
That is correct, other than on appeal. But those principles, yes, I accept, have held good until 2013. But since 2013, certainly one doesn't see a tsunami of revocation applications coming before the High Court. One doesn't see the floodgates being opened. Far from it. In those circumstances, we suggest that there doesn't appear to have been any erosion of the underlying social policy in relation to permanence and stability. In fact, my Lord, we think that there are only two cases ever in which the inherent jurisdiction has been used successfully to obtain an order to revoke an adoptive placement in circumstances where there have been no procedural problems at the time the original order was made. And those two authorities are RE-PK, reference page 804 of the bundle, 804, the decision of Mrs. Justice Porfley, and the decision of Mrs. Justice Tice in AX and BX, reference 1057. And just dealing with those two cases very briefly, in RE-PK, a child was adopted in 2004 and then sent to live abroad, where she was abused and then returned to the UK 10 years later in 2014 and was reunited with her biological family. Her adopters failed to respond to any of the applications made by the birth mother and was held to have relinquished all responsibility for the child 9 years before and did not intend to oppose the revocation. So the adoption order in that case was revoked, and that is squarely a case in which change of circumstances were held by the High Court judge to justify the revocation. The second case, AX and BX at 1057, the decision of Mrs. Justice Tice, involved two children placed in foster care in 2007, aged 5 and 3, who were adopted in 2011. The placement broke down and the children started to have contact with the birth mother without the adoptive mother's knowledge. They returned to live with the birth mother in 2018, and the adoptive parents agreed to them remaining in her care. And in a similar fashion to the present case, a child arrangements order was made in 2020 restoring the birth mother's parental responsibility. The children in that case applied for leave to revoke and were supported by the children's guardian appointed by the court and were supported by the adoptive parents. Those are the only two reported authorities where there's been a successful revocation application absent procedural error. Although there is another decision of Mrs. Justice Tice.
Yes. we need to adjourn.
Of course, my lord.
Sorry for that interruption, Mr. Goodwin.
Not at all, my lord. I was addressing the court in the context of the social policy considerations generated by the two authorities that we were sent yesterday, and the extent to which the social policy in ensuring the permanency and stability of an adoptive placement was undermined, or would be undermined, if there was an allowance for individual exceptions. I've taken the court to two of the reported authorities. We say there are only two authorities where revocation has been ordered, absent any procedural problems. The two other first instance authorities where revocation was allowed were, first of all, Rio, a decision of the former president.
And I'm so sorry, just before we move away from RE-PK and AX and BX, was argument presented in those cases to the effect that actually, on proper construction of the statutes, the adoption order was final? Or was everyone just assuming that, in your favour, that there was scope for revocation?
There was an assumption that the appellate authorities provided a jurisdictional platform, and there was consideration of whether the inherent jurisdiction should be used on the facts of each case, but the issue of statutory interpretation was not grappled with in those cases because of the assumption of appellate jurisdiction.
Yes, thank you.
The two other cases in which revocation was permitted were Rio, which the court has at 861, decision of the former president, Sir James Mumby, and that was the case where a fertility clinic had indicated that a consent form could not be found for one of the putative parents, and so the clinic and the respective solicitors advised the couple that the only solution was for them to adopt the child in order to give both of them parentage. And then subsequently they applied for revocation of that adoption order, and by consent the application was granted on the basis that the court held, in fact, there had been a valid consent form, and so there had been no need for the artifice of adoption in that case. So the adoption order was revoked, and the Court of Appeal in the present case described Rio as a very specific situation in which the revocation of the adoption order was a formality, albeit an important one. That's at 61, page 61 of our bundle. So I don't include Rio as an example of a case where revocation has been permitted as a result of a change in the children's circumstances. And then
And I think, didn't the Court of Appeal say that it was a case that might alternatively have been dealt with by allowing the appeal to be an appeal to be filed late?
They did exactly that, my lord, and they said that in respect of a number of the previous first instance authorities, including this next one, which is the fourth one I allude to, the decision of Mrs. Justice Tice in ZH and HS in 2019, which we have in the bundle at 882. I don't need the court to turn to it, but it involved an adoption order in favour of an aunt and uncle in the UK, the mother having been refused asylum in Holland. But when the adoption order was made, there were multiple very serious procedural errors. The parents, the local authority and the child should have been made parties. The parents weren't served with notice of the adoption application. The father's consent to placement was misinterpreted as consent to adoption. And so the mother arrived in the UK and applied to revoke under the inherent jurisdiction. The application was granted. But plainly, as my lord has just observed, that could have been disposed of by an appeal out of time. And we agree that this case, therefore, does not fit into a category of revocation cases in which adoptions have been revoked as a result of a change of circumstances. So we're left, in effect, with two decisions only. And in our submission, that is a point to raise against the social policy floodgates argument on the authorities and raised by the Secretary of State. Insofar as JR 123, the decision in that case was made in part so as to avoid the need for individual case-by-case assessments of an individual's right to rehabilitation as an ex-offender. There is no suggestion in the present context that there will be multiple cases put before the court.
But that wasn't the concern. The concern was the effect on the minds of adoptive parents and the children of knowing claim for revocation. That was the problem, not the expected incidence applications.
But, my Lord, that is certainly the asserted problem, but insofar as I am drawing attention to there being only 2 reported authorities in the last 13 years, adoptive parents can be told how seldom these applications succeed, and the 2 authorities I've referred to were either by consent or unopposed. There is no first instance revocation decision in which there was a contest of any substance where revocation was the result. There is a single authority.
And sorry, just before you leave that point, why isn't that question a matter of social policy which is properly for Parliament to decide?
Why isn't
the possible impact of the availability, even if it's relatively rare, of revocation of an adoption order, the impact of the knowledge of that upon children and adoptive parents and the formation of identity of the child and the commitment of the adoptive parents to the relationship which affects the child as well. Why isn't the assessment of the dangers of allowing even the possibility of revocation against that background a matter of social policy for which Parliament is the proper forum to make the relevant judgment?
It certainly could be something that Parliament does, but it doesn't need to be, my Lord, and there is no suggestion from the White Paper preceding the 2002 Act and no suggestion within the Act itself that Parliament has considered the very specific circumstances that the children were in this case. I have no difficulty in accepting that Parliament would have considered adoptive placement breakdown generally, but there is no evidence within the White Paper or within the Act, as I say, to suggest engagement with the very particular and unusual circumstances on the facts of this case, where an adoptive parent supports a revocation, where parental responsibility has been restored and identity issues are to the fore.
Yes, thank you.
My Lord, there is one authority only, that of CD and Blackburn, a decision of Mr. Justice Peel in the bundle at 1047. Again, we don't necessarily need to turn to that now, but this is a single authority in which a birth parent has misused a revocation jurisdiction in order to mount, in effect, a backdoor appeal against a care order, a placement order, and an adoption order. She challenged the entirety of the process, including the Section 31 threshold findings and all the welfare decisions. Her case was rejected by Mr. Justice Peel. The Court of Appeal found that there had been an irregularity in deciding to make the adoption order without an actual hearing, contrary to the rules, but that's immaterial to the issues in the present appeal. That was reported as re-IA, which is in the bundle at 1138. But there was no support by the Court of Appeal at all for revocation being used by a birth parent, the inherent jurisdiction being used by a birth parent in those circumstances to achieve revocation. My Lord, we also say that birth parents would require leave in order to apply to revoke under the inherent jurisdiction. Apart from a suggestion by Mr. Justice Peel in the case I've just mentioned that the mother would not need leave to apply under the inherent jurisdiction, none of the authorities has grappled with a leave requirement. But in our submission, it is plain that leave would be required. First of all, under the Family Procedure Rules, Rule 12.3, the inherent jurisdiction applicants include a local authority.
So do we have this in our bundle?
I'm afraid this is not in the bundle, this specific
and is this
procedural rule.
An application under the inherent jurisdiction in relation to what?
This is in relation to, simply in relation to children. It's under the Family Procedure Rules.
Okay.
And Rule 12.3 sets out who the applicants may be, and they are a local authority with the leave of the court, a child, if the case is about wardship, which this isn't, or, and I quote, any person with a genuine interest in or relation to the child. A birth parent would not fall within that category because a birth parent post-adoption is in law a stranger to the child as a result of the extinction of parental responsibility and the operation of section...
I wouldn't have a relationship, like a general interest.
Well, for the following reasons, my Lord, we suggest that a birth parent would not be able to apply without the permission of the court to invoke the inherent jurisdiction. First of all, for the purposes of making the adoption order that would be under review, a parent without parental responsibility is not even a parent. Section 52.
But it's or any person with a genuine interest, you said. I mean, we haven't got it in front of us, but you said it was any person with a genuine interest.
It does say a person with any...
Are you going to address that?
With a genuine interest.
Yes.
But in our submission, if one looks at the position of a parent in other legislation and their right to apply, there is, in these circumstances...
Well, this is not a parent. You've said it's not a parent applying. The birth parents had its rights, his or her rights extinguished. Yes? So they're a person with a genuine interest.
We say it would be difficult to construe a birth parent as having in law a genuine interest in a child who is in law a stranger to them by the extinction of their...
So who's covered by a person with a genuine interest?
I don't know, my lady. I can't speculate. It's difficult to say. If a...
Basically, you're relying upon an inherent jurisdiction, but you want to restrict it so to exclude birth parents.
I'm talking purely about the right to apply without leave.
And you say that runs contrary to the scheme of the legislation, because once a placement order is made, a birth parent would need leave to challenge the placement order. And so the inherent jurisdiction would be inconsistent with the scheme of the legislation. Is that the argument?
We are simply saying, my Lord, in response to the idea that social policy would be eroded if this jurisdiction were recognised, that there are barriers between a birth parent being able to invoke it without leave, and therefore there would be an appropriate filter so that floodgates wouldn't be opened.
I can understand why you want to have a filter, and I understand that. But I was just wondering, upon what basis are you creating this filter? Are you saying the inherent jurisdiction is inconsistent, runs across the scheme of the legislation, which requires, once a placement order has been made, an application to be made for leave to challenge the placement order?
We are categorically saying that the use of the inherent jurisdiction does not cut across the statutory scheme in circumstances where it hasn't been excluded on our interpretation.
Then what is the restriction on a birth parent making an application?
Well, a birth parent cannot apply for post-adoptive contact under Section 51A of the Act without leave. And it would make little sense if a former parent required leave to apply for contact but did not require leave to apply for revocation. Second, under Section 39(1) of the Children Act, a care order may be discharged on the application of any person who has parental responsibility for the child, or the child himself, or the local authority. So
it might be thought to be actually a point against you if the birth parent requires the court's permission to bring an application to have contact with the child. If they did not require, and if they could, without any permission, bring an application to be restored effectively to the parenthood.
well, if they required leave, it would provide the court with an opportunity to filter out unmeritorious applications. As it happens, none of the reported authorities has involved a leave requirement, yet there are only 2 authorities in which it has been done when there haven't been procedural problems. When a child is placed with a special guardian, which is one of the permanence provisions set out in the 2002 Act that falls short of adoption, it is possible to apply for the variation and discharge of a special guardianship order, but under Section 14D(3) of the Children Act, a parent requires leave to apply.
And I'm so sorry, what's the bundle reference for that? Just
2404.
Thank you.
So if a parent requires permission to apply to revoke a less permanent and a less absolute order than adoption, it must follow surely that the parent would require leave before applying to revoke an adoption order.
But there's no statutory provision.
There is no statutory provision, my lady. So accordingly, we say in relation to the social policy issue that the policy can be upheld whilst recognising a narrow exceptionality, and that there is little evidence to suggest that the public policy or the confidence in the public policy would be eroded if this jurisdiction is recognised. It has always been common ground amongst those parties to this appeal who pray in aid of this jurisdiction that the jurisdiction should be significantly curtailed in practice. The judges at first instance relied on the dicta of Lord Justice Wall in the Webster case in saying that once orders for adoption are lawfully and properly made, it is only in highly exceptional and very particular circumstances that the court will permit them to be set aside. And accordingly, our submission is that public policy needs to be weighed against welfare in determining such an application in the manner that was employed by Mrs. Justice Tice in the AX and BX case, which, as we have seen, is on fairly similar facts. My Lord, I wanted to address the court in relation to the use of the inherent jurisdiction in the Re-T case, which was the deprivation of liberty case before this court in 2021. And I refer to page 2258 of the bundle. And I read first from the judgment of Lady Arden. At the bottom of that page, in her concluding section, the inherent jurisdiction plays an essential role in meeting the need as a matter of public policy for children to be properly safeguarded.
So what paragraph is it, sorry?
This is at paragraph 197, my Lord.
Thank you very much.
As this case demonstrates, it provides an important means of securing children's interests when other solutions are not available. And then there follows a citation from Bromley, which is Bromley's family law, which was also cited by Lady Black in that same case. It is evident that the High Court's inherent powers still have a useful role to play. As Sir James Mumby, the President, commented in respect of wardship, cases continue to demonstrate the continuing need for the jurisdiction, which, despite its antiquity, is showing and must continue to show a remarkable adaptability to meet the ever-emerging needs of an ever-changing world. The inherent jurisdiction continues to provide an invaluable additional means of securing certain children's interests who would otherwise not be safeguarded. Now, in the Re-T case, Section 25 of the Children Act regulated, as the court knows, the circumstances in which a looked-after child may be placed in accommodation provided for the purpose of restricting liberty, i.e. secure accommodation. Certain statutory criteria had to be met, and the accommodation had to be approved by the Secretary of State under the regulations. It was a further feature of the case that a children's home had to be registered with Ofsted under the Care Standards Act, and it would be a criminal offence to manage the home if unregistered. In the Court of Appeal in Re-T, no party had taken at that stage any issue with the use of the inherent jurisdiction to meet the needs of this group of vulnerable children for whom there was no place in an approved secure children's home. And Lady Black at 2226 cited the observation of the President, Sir Andrew Macfarlane. I refer to paragraph 64 of the Re-T.
Sorry, page?
2226, paragraph 64. Sir Andrew Macfarlane had indicated as a primary justification for the continued use of the inherent jurisdiction with respect to children in modern times is to provide protection for young children when their welfare demands it. It would be difficult to argue against the assumption of jurisdiction in such cases. Lady Black and my Lord, Lord Stevens, both addressed the use of the inherent jurisdiction when no other option was available to meet a child's welfare needs. I move forward in the judgment to the judgment of my Lord, Lord Stevens at page 2250, paragraph 168. As Lady Black has set out, the inherent jurisdiction of the High Court in relation to children is wide. It is the ultimate safety net. To my mind, the central focus of this aspect of the inherent jurisdiction is on the welfare and safety of children rather than on the potential commission of a criminal offence under the Care Standards Act. Now, one of the prominent issues in the Re-T case was whether or not the restrictions in Section 100 of the Children Act precluded the use of the inherent jurisdiction, because Section 102D provided that no court should exercise that jurisdiction with respect to children for the purpose of conferring on any local authority power to determine any question which has arisen or which may arise in connection with any aspect of parental responsibility for a child. Lady Black addressed that at 2236 in paragraph 113, in which her ladyship said that the restrictions placed by Section 100 should be put carefully into context. The court should not be led into an interpretation of them which focuses so intently on the detail of the legal theory underpinning the words that the intended sense of the provision as a whole is lost, with consequent damage to the ability of the High Court to react when the assistance of the inherent jurisdiction is truly required. And then about 5 lines further on, she referred to the citation from Bromley's family law to the effect that courts should be slow to hold that an inherent power has been abrogated or restricted by Parliament and should only do so where it is clear that Parliament so intended. I would endorse that as being of particular importance when the inherent power exists for the protection of children. There was, of course, an argument in Re-T. The appellant child argued before this court in Re-T that the inherent jurisdiction would cut across the statutory scheme because the unregistered placement was intended to restrict liberty and therefore was secure accommodation that was unapproved by the Secretary of State, and being unregistered, the person who managed it would be guilty of a criminal offence. And there were said in that case to be practical objections to that course, in that the most vulnerable children would be placed without the protection of the express statutory provisions about secure accommodation. The court concluded, page 2242, paragraph 138, that a decision to place a child in approved accommodation outside the statutory scheme involved no conflict with that scheme, because a placement that was not designed for use as secure accommodation, didn't have that as its primary purpose, did not fall within the scheme. Lady Black then pointed out, at paragraph 139 over the page, that the analysis was more problematic where the placement's primary purpose could properly be described as secure accommodation, but where it was unapproved by the Secretary of State. Would that not cut unacceptably across the statutory scheme? And she concluded in the last 8 lines of paragraph 141, cases such as those to which I've alluded earlier in this judgment demonstrate, it seems to me, that it is unthinkable that the High Court, with its long-established role in protecting children, should have no means to keep these unfortunate children and others who may be at risk from them safe from extreme harm, in some cases death. If the local authority cannot apply for an order under Section 25 because there is no Section 25 compliant secure accommodation available, I would accept that the inherent jurisdiction can and will have to be used to fill that gap without clashing impermissibly with the statutory scheme.
Slightly different background, isn't it, of extreme harm and in some cases death.
That is the extremity of the argument, my lord, but there may conceivably be situations, as was recognised by the Court of Appeal in the present case, in which a child's position and welfare have been so compromised by their identity issues that Article 2 and Article 3 rights are engaged. And I refer the court to the Court of Appeal decision below at page 67 of the bundle, paragraph 69, when the court indicated that the court is, of course, required to act within a human rights framework, and it is possible to imagine such an extreme situation arising that the revocation of an adoption order becomes necessary if the court is to comply with its convention obligations. However, the remedy in such a case would almost certainly be an appeal out of time and not an originating application. Further, it is highly unlikely that the Article 8 right to respect for family life or for personal identity could ever be of such weight as to justify an outcome that is at odds with the statutory scheme of adoption that has prevailed in this country for a century. So the Court of Appeal did appear to recognise the possibility that an extreme case would arise, perhaps where Article 2 or Article 3 issues were engaged, in which an argument could be put in support of revocation. And if that is the case, there needs to be, we say, a jurisdictional platform for those rights to be aired. The decision on jurisdiction made by Mrs. Justice Leven, in this case at first instance, gives children in that position no platform at all in which their welfare post-adoptive breakdown can be evaluated. I well appreciate that my Lord Stevens and Lady Black in RET drew attention to the need for conditions of, quote, imperative necessity to be met before the inherent jurisdiction could be invoked so as to place a child in an unregistered children's home that served the function of depriving them of their liberty. We reject any suggestion that those type of circumstances could only arise in the context of Articles 2 and 3. It is conceivable that an identity dilemma could still exact harm on a child within the confines of Article 8, albeit the Court of Appeal indicated that it would be highly unlikely that such circumstances would arise.
And we'll understand why the door is left slightly ajar in paragraph 69, but I was just trying to actually imagine or envisage an Article 2 or 3 case that required an adoption order to be revoked. I mean, there's no example given in paragraph 69, and I was just wondering whether you can provide any assistance about that.
The only assistance I can provide is by reference to page 261 of the bundle, which is the Association of Lawyers for Children's written case, that paragraph 47, in which the ALC says it recognises that Article 8 considerations are highly unlikely to justify the use of the jurisdiction where no other option is available to revoke a properly made adoption order at first instance. That said, the circumstances of a cohort of children and young people who are adopted may, in an exceptional case, engage Articles 3 and 2, particularly where the child or young person's mental health has led to self-harm, absconding with exposure to criminal or sexual exploitation, and attempts at their life, and other manifestation of trauma which may meet the high threshold of those articles.
Well, I can see that if the positive obligation under Article 2 or 3 is engaged, the state has to take various actions, and reasonable actions, and put in place protections. But I was just wondering why those protections involve revoking the adoption order.
Well,
usually it's protecting people and removing them from the area of self-harm, providing medical assistance, so on.
If to run with this extreme example, if a child's mental health or deteriorated as a result of being saddled with an adoptive identity which that child wholly rejected, in an extreme case, it is conceivable that the child could self-harm and suffer poor mental health, so as to engage those articles. And absent some form of platform on which those welfare concerns can be evaluated, the child's welfare and welfare needs and convention rights potentially would not be respected. There was a further allusion, I think at paragraph 63 of the Court of Appeal judgment, which is at, bear with me, page 66 of the bundle, there's a further suggestion that a revocation jurisdiction should be entertained in other circumstances. So the Court of Appeal had indicated later on in the judgment, as we've just discussed, the possibility of an extreme situation arising that engaged convention rights. But at 63, the Court indicates there may nevertheless be very narrow and specific instances in which the High Court finds it necessary to entertain an application to revoke an adoption order, but they will only arise where, for some reason, an appeal in or out of time is not possible.
Does the court explain on what basis it could entertain?
I'm sorry, my lord?
Does the court explain the basis on which such an application could be entertained?
It doesn't. It doesn't explain the basis other than by allusion to a case of G&G, which is a decision of Mr. Justice Headley in a surrogacy case. And in that case, a parental order was made, but the father applied to revoke it on the basis that the relationship between him and the mother had not been settled, and that she had been having an affair at the time the order was made, such that the surrogate mother, he said, would never have consented to the parental order if she'd known the true facts in the first place. Mr. Justice Headley rejected in that decision the notion that the parental order problem could be addressed on appeal, because if, after a successful appeal, the parental order had been set aside, the surrogate mother would simply have refused her consent, and the court would not have had the power to override that. So in G&G, an appeal was not an appropriate resolution. But the Court of Appeal in the present case does not explain how that, by analogy or otherwise, would sit with an adoptive context. So, unfortunately, my lord, there is no context for their conclusion at paragraph 63 that there may nevertheless be narrow and specific instances in which an application should be entertained.
Could I just take you back to the point you were making on the ALC's case, paragraph 47, about Articles 2 and 3?
Yes.
I mean, if one's really straining one's imagination, you could think that a natural child might be so disgusted with their natural parents that their self-identity is compromised in some way that leads to issues arising under Articles 2 and 3. I mean, there wouldn't be scope for a court to intervene in that sort of situation to change the parenthood. I mean, the state would react to that sort of situation by providing care for the child to protect them against the Article 2 and Article 3 harms, wouldn't it?
That would be absolutely right.
So why does it make a difference that the parenthood has been assigned by the court in making an adoption order?
Because the adoptive status of the child in those circumstances is, on one reading, a product of only of law, and it therefore, to an extent, is an artifice vis-à-vis the biological parent, and is therefore capable, we say in law, of being undone in a way that biological parenthood isn't.
And then would that be discriminatory against natural children? If you could take action in relation to adoptive children, but not in relation to natural children, would that discriminate?
I think it would be difficult to conclude that they would be discriminated against in circumstances where their relationship with their parents was the product of biology rather than law, my lord.
A natural child's status is as much a product of the law. Adopted child's.
Well, it doesn't flow from a court order. Parental responsibility might flow from a court order to, for example, a father who was not married at the time of birth.
Court orders. You phrase matters in terms of being a product of the law. All these matters of state.
I think the phrase you used was it's a legal construct, and I think what my lord's putting to you is it's a legal construct in the case of natural parents. It's just that the construct is created simply by the direct application of the general law rather than a court making an order in relation to it. But it's a legal construct in both cases.
Well, I seek to distinguish a position where it's not the product of an order and a situation in which an adoption order has been made.
Yes, thank you.
My Lord, I'm conscious that there are a number of matters that the court has asked for further responses on. Apart from those matters, I have come to the end of the oral submissions on which I had wished to address the court, save to say that you have a fairly exhaustive exposition of the previous case law in our written case and in the documents filed by other parties. I don't intend to take the court through those cases orally unless that would be of assistance. I do accept that the appellate cases in which adoption orders have been revoked involve, as I said at the outset, the Court of Appeal exercising its powers after a successful appeal and weren't plainly the exercise of an inherent jurisdiction, albeit that has been misinterpreted by judges at first instance from 2013 onwards. However, we do say that in none of the appellate authorities has the precise circumstance of the present case been considered, and accordingly that none of those authorities rules out the possibility of the inherent jurisdiction being used in extreme cases. Does the court want any further assistance in relation to any of the case law that we set out in our written case?
Can I just ask you, if I may, just a last question on paragraph 69 of the Court of Appeal's judgment in this case, which you took us to, where they say it's possible to imagine an extreme situation arising that the revocation of an adoption order becomes necessary if the court is to comply with its convention obligations. Just wonder whether that's actually, the court is looking at it too narrowly there, because if one's dealing with a situation where the child is suicidal or something like that, there are other mechanisms that exist where the state can react to those sorts of problems, for instance, by taking the child into a hospitalised situation, providing care to them so that they don't, in fact, kill themselves. So isn't it too narrow just to say, well, the court's got to solve all these problems, therefore the court has to have a jurisdiction to revoke, if there are other state mechanisms that exist that, in fact, are created to deal with those kind of problems? And if those other mechanisms exist, then it might be thought the whole pressure comes off the court as having to solve that particular problem, precisely because those other mechanisms exist in the state to do so.
I agree that there may be other state mechanisms that can be brought to bear on a child's dilemma and to alleviate any harm that might pertain to the child. But, my Lord, there may be circumstances in which that is insufficient, because in the context of this case, the child's dilemma at its very root goes to the perpetuation of an adoptive identity that the child rejects and continues to cause the child harm. If that proves not to be susceptible to other state mechanisms and to be alleviated by those mechanisms, then potentially the court would need to exercise a revocation jurisdiction in order to put at its root the problem right.
Yes, thank you.
The whole sort of thinking, both of you and of the Court of Appeal and all these authorities, is if a child's welfare requires it, then the jurisdiction must exist. I mean, it's actually the other way round.
Well, that's certainly our submission, my Lord, and appears to be the thinking of the Court of Appeal, which is that the inherent jurisdiction should be available to meet a child's welfare needs if there is no other means available. I'm in the court's hands as to whether learned friends make any submissions now or whether the court wishes to adjourn and to give
we
the
don't want to
parties...
adjourn. It's not even 10 to 1 yet.
No, and to give the parties a chance over the short adjournment to consider the points that had been previously raised.
Well, let's get on and try and make some progress with this appeal.
Thank you, Lord.
Yes.
Lady, of course, the court has indicated a wish to go on. My Lord will see that the position on behalf of BM has been very much to support the legal position put on behalf of the appellant. And as a result, I had provided for 15 minutes of speaking time in support of BM's case. I have been listening most carefully, of course, to my learned friend Mr. Goodwin, King's Counsel, and the court's interventions. And it would be my application, if you would permit me to make it, for there to be an adjournment at this stage so that I can consider the authority of Abbasi that the court raised at the start of this hearing.
I mean, Abbasi is not really saying anything revolutionary. It's just, it discusses the parents patriae jurisdiction in a little more detail than usual. It just makes the point that this is it's a jurisdiction going back to medieval times that vested in the monarch to look after the property and persons of people who couldn't look after themselves. And it certainly came to an end when the ward came of age. You know, medieval kings would take into their hands the estates of heirs who were underage and either hold on to them themselves or give them to their household knights and so forth, and benefit from that. But the minute the heir came of age, it had to be handed over. And you know, that's where it comes from. All the authorities are to do with children, and so I struggle to see how it can apply to people who are over 18.
My Lord, I have one or two additional submissions to make in respect of the inherent jurisdiction.
Yep.
I'm simply going to indicate that I might be more articulate in those submissions if I have the opportunity just to confirm that the submissions I make are not contradicted by the Abbasi authority. Perhaps if, rather than to waste time, I make those submissions but have the opportunity of the short adjournment to reflect if my further reading requires me so to do.
If they want.
Very well. Well, in that case, shall we aim to sit again at 10 to 2?